started. First of all, I'd like to welcome all of you on behalf of this International Legal Studies. Good morning, good afternoon, and good evening. I think we've got attendees from every corner of the globe. I promised Ishan and the panelists I would stay very short. So I just want to thank Ishan for organizing this and recruiting 5 excellent panelists. And I'd also like to thank Arbitral Women, the New York International Arbitration Center, and last not least, Transnational Dispute Management for endorsing the seminar. And with that, Ishan, the stage is yours.
Thank you, Chris. And good morning, good afternoon, good evening, ladies and gentlemen. Welcome to CILS and Arbinsol's webinar on international arbitration, insolvency, and third-party funding, the post-pandemic state of affairs. Our times are unprecedented, and so are the challenges. The pandemic is on its course to alter some or many of the ways of the world. International trade, commerce, investments, and disputes have been no alien to the wrath of the pandemic. Drastic preventive safeguards and measures have been taken by states across the world, which have resulted or are resulting in impaired abilities of businesses to perform contractual obligations. Many businesses are likely and perhaps are already seeing that they may be on the brink of insolvency. The long-term impacts are yet to be seen, but we are bound to see an evolving application of laws. What happens to contractual obligations? What is the fate of arbitration agreements? It may so happen that parties to an arbitration agreement may go insolvent either before or during the subsistence of arbitration proceedings. It may also happen that insolvency may get triggered as regards a party or parties after the passing of the award. Do arbitration agreements become meaningless when insolvency gets triggered in respect of a party? A financially incapacitated party may still seek refuge with a third-party funder to pursue its claims. What promise in the future do third-party funders hold? In a cash crunch environment, respondents would press hard for security for costs to avoid arbitral hit and runs. How does that work? To answer these and much more, we have with us today a very special and esteemed set of panelists with a diversity of experience, from arbitrators to arbitration counsel to third-party funders. We are here to take a peek into the future. In order of sessions, please allow me to introduce our panelists. Professor John Rooney, an international arbitrator, adjunct professor, Miami Law, vice chair of Miami International Arbitration Society, and a Fulbright specialist in law of contracts. He has arbitrated and continues to arbitrate or practice as an arbitration lawyer in the US, Latin America, the Caribbean, Europe, and ICSID. With both civil law and common law training, Professor Rooney is barred in Texas, Louisiana, and Florida. He's also teaching at Miami Law, International Commercial Arbitration and International Business Transactions. We also have with us Kiran Nasir-Gore, an international lawyer based out of Washington, D.C., practicing primarily in public and private international law. She's also a lecturer at George Washington University Law School and at NYU, D.C. Kiran is also an associate editor at the esteemed ICSID Review and the much celebrated Kluwer Arbitration blog. Kiran has a special focus on asset and debt recovery. Up next is the youth favorite, Dr. Kabir Duggal, a highly accomplished young lawyer, barred in New York, DC, India, England, and Wales. He's practicing as a counsel at Arnold and Porter and handling both commercial and investment arbitrations. He holds key positions in several committees and boards and is a leading author of several important publications on international arbitration. We also have with us Elizabeth Snodgrass, a partner at the Washington, DC office of Three Crowns. She has more than 2 decades of experience as an advocate and counselor in international arbitration matters, both commercial and investment treaty. Her clients span a wide variety of sectors with a focus on upstream energy, power, mining, aerospace, and telecoms. Ms. Snodgrass is recognized in leading directories and rankings, including Chambers, Who's Who Legal, and the Legal 500. And last but not the least, Dana McGrath, an investment manager and legal counsel at Bentham IMF, now Omni Bridgeway, responsible for leading the company's investments in international arbitration matters and contributing to its commercial litigation funding efforts. During her decades of experience in international arbitration, she has earned several recognitions and is a torchbearer enlightening the path of equal representation and diversity in international dispute resolution. She's the current president of Arbitral Women and a mentor for many. She's also an adjunct professor of law at Brooklyn Law School teaching international commercial arbitration. Now, without further ado, I invite Professor John Rooney to talk about the impact of the pandemic on contracts as well as on international arbitration.
Ishan, thank you very much. And thank you for this opportunity to address you on this obviously very important topic. As Ishan mentioned, I will be discussing the impact of the pandemic on contractual obligations and international arbitration. So you could really consider my session to be more in the nature of an introduction. I will be organizing my thoughts in terms of the impact on contractual obligations, force majeure and related doctrines with respect to the civil and common law, insolvency, solvency and liquidity of businesses, emerging issues, and the impact of the pandemic on international commercial arbitration. There's a lot that we do not know with respect to what these effects are going to be. In my mind, what we have, of course, is a pandemic, and we have a pandemic that is creating effects, and the two are not necessarily the same. When we speak of force majeure, when we think of, for example, acts of God or acts of nature, obviously we're thinking in that sense about the virus itself and its spread and the effect that it might have with respect to the execution of obligations or resolution of issues when the obligation cannot be executed. And then on the other hand, we have effects that the pandemic will create, in particular with respect to actions of governments in connection with management of public response to the pandemic. There will be situations, for example, where there will be orders or instruction from public authority indicating that certain sectors of the economy, for example, will have to shut down for a period of time. There will be others that will indicate that there will be a division of function, for example, with respect to essential and non-essential services that will also have an effect with respect to the effect that the pandemic will have. I think in both cases, the effects may be similar, but not necessarily the same, and not always susceptible of prediction with respect to what their result would be. One of the things that we see, for example, is that the different legal systems and the different orders with respect to regulation of contracts have taken somewhat different approaches sometimes with respect to an event like the pandemic and the effect that it would cause. If we look, for example, at the CISG, first we must note with respect to the CISG, the Vienna Convention on Contracts for International Sale of Goods, that it is, of course, an instrument of public international law, and that it does not cover the entire range of contracts. But it does, in its Article 7, deal with impediments to performance of contracts, and deals, in fact, with the concept of impediment in terms of regulating when it is an impediment exists, assignment of burden of proof, liability, and responsibility for damages in the event that an actionable impediment can be established. If we look at the UNIDROIT principles, and the UNIDROIT principles, as we know, are not the law, they're not really the law anywhere, but because of the wording of Article 28 in particular of the Unstrom model law, as a rule of law, they are often applicable in the context of international arbitration. Unidroit addresses both the concept of force majeure and the concept of hardship. Force majeure is addressed at Article 7.1.7. Hardship is addressed at 6.2.2. The treatment of force majeure is somewhat similar in Unidroit to what we see, for example, in the 2016 reform of the French Book of Obligations, where where France now specifically defines what is a force majeure event and provides a division between what we would call something that makes performance impossible or something that would suspend performance. Which was different from the prior law, which basically just used the term force majeure and didn't indicate exactly what its content was or what its effect would be. And then, of course, you just have the possibility of the Unidroit principles being used as a gap filler, both with respect to the CISG and with respect to other aspects of national law. But I think that what is important to recognize is that we have a structure with respect to rules and regulations, both at what we would call a public international law level in the CISG, and a statement of principles with respect to Unidroit that, of course, also have their effect as well. Then when we turn to national law, the situation can be somewhat different. As I mentioned before, France, before its recent reform, as I understood it, only referenced force majeure and didn't regulate the particular application of the principle. Other countries will have, civil law countries will have different approaches to the regulation of force majeure. But one of the questions would be, for example, whether the disposition in positive law would have elements of public order and could or could not be modified by the parties in their respective agreements. The situation changes a bit with respect to the common law, because the common law typically is not going to have a set of obligations set forth in positive law in the form of a code that would deal with these issues. Although jurisprudentially, or in terms of the case law, most common law jurisdictions have developed principles through judicial decisions, for example, impracticability with respect to performance of the contract or frustration, that can be analogous with respect to their application. Just a moment. The common law can differ in the sense that the jurisprudentially established principles with respect to dealing with unexpected circumstances in the context of the performance of the contract can typically be varied by the agreement of the parties. And those of us who are used to dealing with either drafting or dealing at the dispute level with respect to sophisticated contracts find that oftentimes that there is a provision for force majeure, even when the contract is governed by the common law. And that the provision with respect to the force majeure typically will first follow a general pattern with respect to the nature of the act, whether or not it effectively makes performance impossible point forward, or whether or not it is such that performance might be possible after a period of time. Oftentimes you'll see an agreement that will basically say, for example, if the act persists for more, for example, than 6 months, it might be considered to be permanent. And at that point in time, a party could ask for termination of the contract. the pandemic is going to present some very, I think, unique circumstances that are going to affect both the application and development of those principles going forward. Also with respect to insolvency, and I'm not going to get into a lot of detail with that because many of the other panelists will more specifically deal with questions of insolvency. But one thing that we all realize is that the pandemic has provoked in probably all of our respective jurisdictions some type of legislative response. And in some cases, the legislative response, for example, has affected the ability to file an action for insolvency for a period of time. Not the case in the United States, but in other jurisdictions that would be the case. In the United States, we have certain kinds of assistance that the government provides. One is considered to be a type of payroll protection. And when Congress drafted and the president signed the legislation after passage by Congress, that program effectively makes the benefits unavailable to a debtor in a bankruptcy proceeding in the United States. But there are other issues that we're going to have to deal with as well. One of which is, for example, when you have a standing or an existing insolvency proceeding at the time that the measures, not actually necessarily with respect to the measures, but with respect to the effect of the pandemic on the party that has sought bankruptcy protection. I think over time what we will see is that if the debtor's viability is ultimately affected by the suspension of activities, for example, by the pandemic, that matters that begin as a request for a kind of reordering and administration of the debtor's affairs so that the debtor can effectively get back on its feet and become solvent again, might in fact be converted more frequently now into the procedure for liquidation of the enterprise, recognizing that perhaps the period of time for recovery is too long, or that the matter will and that the entity in fact will no longer be viable and unable to survive. With respect to the impact on international commercial arbitration, I think a couple of things. One, we do have situations, obviously, in which insolvency intrudes in the arbitral process or vice versa. A typical contract that contains an arbitration clause in most jurisdictions obviously will be enforceable, and that an alternative form will be available for the parties in connection with the resolution of their disputes. Insolvency, of course, can change a lot of those rules. One is the ability of the bankruptcy representative, for example, to declare certain types of contracts to be unenforceable, and whether and to what extent they might decide that an arbitration agreement, for example, would be enforceable. Another example would be where an arbitration clause, because of its breadth, might include an issue that might otherwise be just a moment here, that would otherwise be the province of the bankruptcy jurisdiction. We had a recent case in the United States where the question of whether the action of a party had violated the stay that the bankruptcy law imposed on the activities of the party that was undertaking the action. The question of whether there was a violation of the stay in the presence of an arbitration clause would be resolved by the arbitrator or be resolved by the trustee. In that particular case in the United States, both at the lower level and at the appellate level, the decision was that in fact that would be the province of the the bankruptcy representative and not of arbitration, and the non-executability of the arbitration agreement was confirmed by the lower court. With that, I see that my time is almost up. As I believe Ishan had mentioned, should you have any questions, please feel free to indicate them in the question or answer section or in chat. And with the remaining 15 minutes after we've done our presentations, we'll be able to address your questions. Thanks a lot.
Thank you, Professor Rooney. And now we move to something that I consider as one of my favorite questions, and perhaps the one that creates the most perplexities. What happens when there is a conflict between international arbitration and insolvency of one of the parties concerned? We now move to Kiran Asir-Gore to discuss more about this.
Thank you, Ishan. Before I begin, let me really truly share my thanks with both Chris and Ishan. Not only have they put together a wonderful group of panelists, but also a great group of participants. And I've looked at the list of names and I see many familiar names and new names. I'm just delighted to be here with all of you today. We're discussing the state of affairs in the context of an unanticipated global health, commercial, and legal pandemic in many ways. And all of these elements are changing the way that we each live, learn, and do business. It's a truly jarring set of circumstances. And in this instance, I would say that it would be helpful to ground ourselves. So before we go into the post-pandemic state of affairs, I want to start us off with a few foundational and well-established ideas which relate to the intersecting and twin topics of arbitration and insolvency law. So to start, international arbitration, definitely considered one of the most desirable and effective ways to resolve cross-border disputes. And its popularity is steadily confirmed through increasing caseloads at leading arbitral institutions, corporate user surveys, empirical studies on the use of arbitration agreements and cross-border contracts, with Professor Rooney just talked about a little bit, and also in the growing number and kinds of disputes that you see resolved through international arbitration. The 2018 Queen Mary survey focused on the evolution of international arbitration, and it showed some really interesting results. 97% of the respondents showed that international arbitration is a preferred way of resolving disputes, either alone or in conjunction with other kinds of ADR. The enforceability of awards continues to be perceived as arbitration's most valuable characteristic, and other great qualities of arbitration include avoiding specific systems of national courts, perceived flexibility, and perceived ability of parties to select arbitrators. Costs continue to be one of the main concerns, and 99% of respondents to this Queen Mary survey would recommend international arbitration to cross-border disputes in the future. So we start from a point where international arbitration is incredibly desirable and preferred by many users. Meanwhile, insolvency comes with its own set of principles. As a starting point, insolvency is simply the state of being unable to pay money that's owed on time. This could stem from any number of the circumstances that Professor Rooney just described, either force majeure, inability to perform contracts, absolution from contracts that already exist. But in any event, the definition, a party's state of being unable to pay the money that's owed on time, is adopted widely. It's one that would be used by business analysts. It's one that is employed as a starting point in the Uniform Commercial Code, the UCC, which is the basis of much law in the United States. And there's two forms of insolvency: cash flow insolvency and balance sheet insolvency. In general, when you come to the idea of insolvency law, the goal is twofold. First, there's the idea of collective liquidation for the benefit of creditors, and then there's the idea of reorganization proceedings, where the proceedings offer the debtor a continuing existence, aiming to provide some restructuring that can benefit not only the debtor, but also its creditors. So therefore, when you come to insolvency legal procedures, they try to account for a variety of activities. So when we talk about insolvency procedure, we're talking about everything from liquidation, rehabilitation, appointment of a trustee, which we just heard a little bit about from Professor Rooney as well, receiverships, any kind of procedure that's designed systematically to resolve these problems. Where it gets incredibly complicated and where international arbitration and insolvency start to intersect is in the realm of cross-border insolvency. So what's cross-border insolvency? How is it different from regular insolvency? Cross-border insolvency encompasses all the legal provisions that could apply where the insolvency in one jurisdiction could affect actions in another jurisdiction, where there's some kind of international element, and the involvement of foreign creditors or the location of assets in another country might be ways that you see this kind of intersection happening. Now, where you do have this intersecting world, you also see the necessity for international cooperation. As we all know, so many of our listeners are from a variety of jurisdictions. We all know that national laws are not necessarily comparable, and insolvency is inherently a national concept, and insolvency laws are inherently national and domestic. So where we do have these cross-border elements, theoretically, we end up dealing with two different frameworks, territoriality and universality. And they're not necessarily dichotomous to each other, just far broad ends of the spectrum, universality on one side and territoriality on the other. So universality speaks to the unity of proceedings and takes the idea that all the assets of a debtor should be considered together, irrespective of where they are located. So when we talk about insolvency, especially in this post-pandemic world, where we do have more insolvency proceedings being initiated, or possibly the moratorium on such proceedings, it's important to take stock of the full nature of assets that might belong to a company or a business. Territoriality, on the other side, focuses specifically on the effects of insolvency on a particular, the assets in a particular jurisdiction. So they're at opposite ends, and you'll find that most jurisdictions will take some intermediary position, but it's important to see that the scope of assets can be defined differently depending on the national jurisdiction that you're dealing with. So when it comes to dealing with insolvency proceedings in the context of international arbitrations, Ishan mentioned this in his introductory remarks, which were quite eloquent. Insolvency can come up at a variety of stages. It could come up before an arbitration is commenced, during the time an arbitration is pending, or after an arbitration has concluded, but before the award has been satisfied. So we see a consistent theme here in the sense that the 164 contracting states, the New York Convention, have the New York Convention to provide a guiding light. So with respect to any arbitration and insolvency proceedings that might intersect before an arbitration is commenced or while it's pending, the New York Convention provides us guidance on what's the effect or what's the legal meaning of an arbitration agreement that might exist. On the far other end of the spectrum, according to the New York Convention, we can look at public policy, whether an award is enforceable under national public policy, but we can also look at whether that award actually will be enforced. So it's the legal effect of that award at the conclusion or after the conclusion of an arbitration. So you see that the New York Convention provides a framework, a supportive framework during the pendency of all these various aspects of an arbitration. We know that in this post-pandemic world, we're on the cusp of many different disputes that could arise from everything as simple as a breach of a sales agreement to something that might be more significant. And if we try to navigate what this will mean in the insolvency space for arbitration proceedings, we start to see that cross-border insolvency and how cross-border insolvency is dealt with by different tribunals and courts becomes incredibly important. I'm going to talk about the procedures and those intersecting ideas from two different lenses. The first is about what to do with an arbitration proceeding and insolvency, where the insolvency begins before the arbitration or during, and then separately at the enforcement phase. I think they can be treated in that way. So there are a few ideas that you need to deal with at the beginning. One is the validity of the arbitration agreement. Professor Rooney touched on this briefly. The other is the capacity of the parties to an arbitration agreement, and the other is what does the arbitral procedure look like. And to give you a sense of how all these elements play out, I'm going to very briefly recap a case that some of you may have heard about or read about. It's the Electrum versus Vivendi cases. So these disputes involved a couple of companies in a couple of countries. So there was a dispute between a French company and a Polish company over the ownership of shares in a Polish mobile telecom company. And there were arbitration and court proceedings filed in a couple of different jurisdictions. There was an English case before the LCIA with an LCIA arbitration clause. And there the dispute was over the interest to be acquired in that Polish telecommunications company. The case, the arbitration, commenced in 2003, and the hearing was scheduled for 2007. Meanwhile, there was also a Swiss case involving an ICC arbitration clause, which concerned an unsigned settlement agreement between those same parties. This dispute, the arbitration, commenced in 2006, and the hearing was scheduled for 2007. It sounds like everything would have gone all well, except in 2007, Electrum entered insolvency proceedings in Poland. And the two tribunals were informed, and by February 2008, the Warsaw Court had revoked Electrum's powers of self-administration. And so Electrum went to these two tribunals in two different jurisdictions. We're talking 3 jurisdictions already. And in both arbitrations argued, well, look, the Polish bankruptcy law expressly invalidates our arbitration clauses and discontinues these proceedings. These proceedings must be stayed and cease to exist. Your jurisdiction, your competence has ended at this point. And of course, these tribunals do have competence, and they decided to rule on the nature of their own jurisdiction. So we have the LCIA tribunal saying, well, English law governs, and we actually do still have jurisdiction. We are going to go ahead with exactly what we were already doing. Who cares what's happening in Poland? Meanwhile, the ICC tribunal decides, yes, Polish law governs. The tribunal no longer has jurisdiction, and these proceedings are discontinued. Both of these partial awards issued by these 2 different tribunals in 2 different countries were upheld by the respective national courts of those proceedings. So the English High Court upheld the decision of the LCIA tribunal. The Swiss court, the Federal Supreme Court, upheld the partial award of the ICC tribunal. And so you see this dramatically differing approach, which is truly baffling for this Polish bankruptcy court to deal with. So what you really see illustrated through these cases, or the scenario case, is that a tribunal's jurisdiction and its choice of law are really dependent on how it chooses to observe the insolvency of one party and what that means for its competence and its jurisdiction and its future administration of the proceedings. Tribunals, as opposed to national courts, don't have a lex fori, a proper lex fori. They just have the law that's been appointed to them as the substantive law governing the contract or the procedural law of the seat. So they, in many ways, they remain detached from the territory of their seat because they're not necessarily engaging with that law. And meanwhile, the impact of the insolvency on the arbitration agreement can have differing impacts. So there might be an issue about the validity and enforceability of the arbitration clause, and that goes to capacity. I'll talk about that a little bit more in a couple minutes. There might be what that means for the conduct of the proceeding. So whether the arbitration must be suspended. It's exactly the issue that the LCIA and the ICC tribunals in Vivendi dealt with. So when you look at this tension, it's really unclear what the tribunals may do. And it's also, what's very clear though, is that the tribunals will not take a consistent approach. Tribunals will use their mandate, right? That's really what we're focused on. What is the mandate of the tribunal? What's the justice for them to do? They'll use that power to decide how best to administer the proceeding going forward. So there's plenty of studies that have been done on how this tension has been treated. I'm not a researcher myself, so I won't take credit for any of the research that's out there, but there's plenty of case studies following Vivendi about what this looks like. And what you find in those studies is that, number one, common law and civil law tradition countries will treat the legal effect of a bankruptcy proceeding and insolvency proceeding differently. And because that law, the law of the seat, will treat things differently, it's possible that the tribunal will treat things differently. So we start to get a spectrum of what this means. We also have seen in some of these studies that arbitral tribunals are receptive to arguments of pacta sunt servanda. So this idea that the contractual nature of the international arbitration impacts party autonomy. And there is this element of party autonomy. If this particular dispute was determined between the parties consensually to be appropriate for arbitration, it might outweigh the policies underlying insolvency law. Another element that you see playing out amongst the decision-making of tribunals, or the ideas underlying their decision-making, are simply that a party does not necessarily need to make a decision as to, or rather the tribunal needs to make a decision as to whether the insolvency is a matter of fact or as a matter of law. So a tribunal could take what I'll call, for lack of a better term, judicial notice of the factual existence of an insolvency proceeding in a different jurisdiction. But that doesn't mean it needs to directly engage with the legal effect of that bankruptcy proceeding, that insolvency proceeding. And part of why that dichotomy begins to really be important from a legal perspective is this idea of capacity. So a party needs to have capacity, as I think we would all agree, to conclude a valid arbitration agreement. But in the same vein, a party also needs to have capacity to be a party to an arbitration, to be a party to an arbitral proceeding. So under the New York Convention, capacity is really a key concept. You can't have a valid agreement or a valid arbitration unless capacity is present. And here, this is another idea that's quite different under different national traditions. So under US law, if a party enters into Chapter 11 bankruptcy proceedings, the party actually retains its capacity. It's only its possessions that are subject to the supervision of the court. Meanwhile, there are other countries where that party, a party that's subject to insolvency proceedings, its capacity is completely nullified. So the question becomes, are they even capable of being party to an arbitration clause, an arbitration agreement? Is that now nullified and void? Or are they even capable of being party to a arbitration procedure? So you start to see how the various mechanisms of insolvency can play into the substantive decisions that tribunals are making. So I see I'm running out of time. I'm going to very briefly touch upon what happens when an insolvency procedure comes up in the enforcement of an award. Under normal circumstances, I would say this is the most interesting topic, and I would have spent the most amount of time in it, but because of our post-pandemic state of affairs, I think it's actually the least of concern in many ways, because we're seeing so many insolvency proceedings come up, or the prospect of them come up earlier now. So we really need to navigate what that means. But the fact remains that voluntary compliance with arbitral awards tends to be relatively high. And so enforcement courts are presented with only, well, what do you, in this context, well, what do you do with a cross-border insolvency? Is it against public policy to have an award issued against a party that is insolvent or has become insolvent? Or if the insolvent company is liquidated, what does that mean for the ongoing business relationships? What's the weight of the award that's been presented? So for enforcement purposes, you really end up in a world, and I've had cases like this that are really jarring, because you've just completed a great arbitration and now you can't collect on the award because you're entering the line, right? You're just joining the other creditors in front of the trustee, and the creditors, they're competing against each other for one pot of money, right? So you put pressure on the trustee to turn down other creditors because your creditor is better, your creditor is more important. What's the dichotomy between foreign creditors as opposed to domestic creditors? How do you prioritize those claims? And at that point, you're in the hands of a court, of a bankruptcy proceeding, of a trustee, of a bankruptcy judge. So you start to see how the recognition and enforcement of an award becomes increasingly complicated, and different nations are free to define what they want to do with domestic and foreign creditors. So the grounds for refusal of recognition, enforcement, and such an award can really become quite complex. So I'll stop there. I just wanted to give you an overview of all the various ideas that come into play, and I think we're about to switch gears a little bit to some different topics that are intersecting but unrelated. So I'll give the floor back to Sean. Thank you very much.
Thank you so much, Karen. Indeed, it gives rise to a big issue when it comes to a dispute between a delocalized mechanism, that is arbitration, and a very domesticated set of laws, that is insolvency. And of course, public policy is looked at differently in every different jurisdiction. But it's a question that has to be discussed in further detail and with more deliberation in the times to come. But for now, let's move to investment arbitration, international investment arbitration, ISDS, and insolvency, how it comes into play. So I will now invite Kabir Duggal to start talking about the same.
Okay. Ishan, just one point. My computer will be a zombie, so if anything is stupid, I need you to correct me and scream out because I can't see anybody. Let me just start off by saying how delighted I am to be here with all of you. I particularly appreciate having these webinars earlier in the day. One of the realities of COVID is that shaving has become optional, showering has become optional, wearing pants has become optional. So I really enjoy the opportunity when I'm forced to do these things. If I may also just add, I never thought I would see over 100 people join us for bankruptcy and arbitration. So I particularly commend you, Ishan, and Chris for putting together such a brilliant program. My topic today is going to be looking at bankruptcy and investor state arbitration. Let me start off by insulting your intelligence. In case you know nothing about investor state arbitration, there's clearly one of you who doesn't know it, and this is for you. Investor state arbitration is arbitration brought by a foreign investor against a state, capital S, a sovereign, a country, a government. And these arise out of obligations provided in investment treaties or in contracts where the state agrees to investor state arbitration, or sometimes countries do it in domestic investment laws. You enact a law and you guarantee investor state arbitration. And these cases are often administered, not always, but they're often administered, the International Center for Settlement of Investment Disputes, ICSID, CILS in Espanol, that's the most popular body. You have the ad hoc arbitration rules under UNCITRAL that are available. Those cases often tend to be administered by the Peace Palace in the Netherlands. Fun fact, it's not a palace and it's not Dutch. Let's come to the point that we're talking about. How will bankruptcy potentially impact investor state arbitration? And to that, I will say it will impact in so many ways. I'm not going to be looking at the policy reasons here. There is some very good scholarship done by the Columbia Center for Sustainable Investment. I see Lisa and Brooke, both are participants here. I'd commend you to look at that. What I'm going to propose to do is I look at how in the past bankruptcy issues have been addressed. in investor state cases, because that can potentially give us some guidance. Now, you can look at this from a myriad of different ways. I have 15 minutes and I actually want to make up time, so I'm trying to go a little quickly. So I'm going to focus on 4 aspects. We'll focus first on substantive protections. Second, we look at procedural requirements. Exhaustion of local remedies is what I'm going to focus on. And then we look at principles of attribution. And finally, if time permits, we look at challenges to arbitrators. All these issues will be looked at in relation to bankruptcy. Now, let me just start off, right? One of the core ideas of investment protection is that you are getting protection from state action. And therefore, the query for us is, if your state action results in a bankruptcy, can you seek protection under an investment treaty? And let's look at cases, because that's how I think we can see how tribunals have dealt with this in the past. Forgive me, blah, blah, blah. And the case we're going to look at is a very tasty case. Yes, I said tasty, because the case's name is Dan Cake versus Hungary. Now, very quickly, what happens in this case? In this case, you have a Portuguese company that acquires a majority interest in an Hungarian company, Danicita. And it was a very fun business, my dream job, only I think I would eat up half the inventory. The business is supplying cookies, cakes, biscuits, all these other fun things. Now, this business does not go very well. And this company, Danicita, is not able to pay its debts. Okay? Now, in this particular framework in Hungary, the Metropolitan Court of Budapest is going to operate as the bankruptcy court. And they declare this company insolvent, they appoint a liquidator, right? That's typically how the bankruptcy proceeding works. Now, let's pay a little bit of attention here. Hungarian law has a procedure where if the debtor can come to an agreement with the creditors, the debtor can request something called as a composition hearing. And this composition hearing is a proceeding where the creditors tell the court to approve the restructuring agreement. So Danicita tries to do this. The court refuses to convene this composition hearing. And instead, what the court does is the court puts a lot of restrictions on this company. Okay? Now, apparently under Hungarian law, the court was not required to impose these conditions, but it did do that. Danicita could not meet these conditions, and so the company eventually gets sold. Now, this matter comes before the tribunal. It's an exit tribunal. And just one quick point. I'm summarizing what is very complicated cases. Please bear with me, but there's no way we can otherwise cover them. Now, when this matter comes before the tribunal finds a violation of the Fair and Equitable Treatment Standard, FET, but it actually goes further. It finds a violation of FET in the form of denial of justice. Now, denial of justice, if you know nothing about it, just keep this in the back of your mind. It's a defense under customary international law, and the bar for DOJ is super, super high. But the tribunal's reasoning was that, the law permitted, Hungarian law permitted an agreement. Here, the court did not allow it, and it also imposed conditions that were not required by the law. And according to the tribunal, this is a very extreme action taken by the court. They think it meets the standard of denial of justice because it shocked their judicial propriety, right? So this is one instance where you're seeing how an action of the bankruptcy proceedings may give rise to an action under investment treaties. Okie dokes. The second issue that I wanted to cover was looking at exhaustion of local remedies and how that impacts bankruptcy proceedings. And we're going to look at the famous Lowen versus United States of America case. This is the case we can critique from a variety of different aspects. Here, unlike the earlier case, which was a happy case, this case deals with funeral homes. And go figure, there are two companies that are competing for funeral homes. You have this Canadian company, and then you have this local family, the O'Keefe family, that runs funeral homes in Mississippi. And Lowen Group and the O'Keefe family enter into a disagreement. O'Keefe starts proceedings before Mississippi, and the jury awards O'Keefe $100 million in compensation and $400 million in punitive damages. I'll just pause here. This is a funeral business. Go figure. This was the biggest award issued in Mississippi, at that time at least. And in the proceedings, the fact that this Canadian foreigner coming to the United States, such arguments were raised very frequently. Now, Mr. Lowen, the Lowen Group and Mr. Lowen had an opportunity to appeal, but under Mississippi law, you had to pay 125%, forgive me, of the damages as a bond. Again, remember, this is a funeral business. Lowen will eventually settle the case with O'Keefe, but will start a proceeding against the United States for the actions of the Mississippi court. Now, the tribunal's decision here is interesting because the tribunal says you need to exhaust local remedies, right? This is not a requirement under the applicable instrument. The applicable instrument was NAFTA, the North American Free Trade Agreement. It is going to die in 6 days and is going to take a new form, USMACA. But that's what the only thing that NAFTA required was waiver of local remedies. Now, the tribunal notes that there were 3 options available. You could appeal before the US courts, although the tribunal does acknowledge that's not a reasonable opportunity here. Or you could have filed for bankruptcy, or you could have appealed to the Supreme Court. Okay, now I just want to point out, they do say one of your remedies actually is to file for bankruptcy. And I think the point that is made by the tribunal is that since you did not explore the bankruptcy or the appeal to the Supreme Court, you did not exhaust local remedies. Another way we see bankruptcy impacting, I know we're probably getting close to time, but the next question that I'll try to do a little more quickly is, are decisions by bankruptcy courts, bankruptcy administrators, are they actually actions of the state? Can you attribute these activities to the state? And this is where you have to look at international law, right? The ILC articles on state responsibility sort of give you a framework, and they tell you what can be an action of the state at a super high level. If you are an organ of the state, you are the state. If you exercise state functions, you are a state. This is the functional test. I call this the duck test. If you walk like a duck, talk like a duck, sound like a duck, you are a duck. And the final point is, if you're under the control of a state, you are the state. This is sort of the framework that you can keep in your mind, in the back of your mind. Now, I give you a case where we see this coming up in the bankruptcy context. This case deals with sausages. So we have dealt with funeral homes, cakes, and now sausages. This is probably one of Croatia's biggest exports. It is this company that does this business. In the 40s, when Yugoslavia was created, right, the company was converted into a social enterprise, and the owners had to leave. The Gavrilović family had to go to Austria, forgive me. Now, in independence, this happens in the early 1990s, all these socially owned enterprises are being reconverted into private enterprises. 9 of these Gavrilovich companies were struggling and they're put into bankruptcy, 5 of which are acquired by Mr. Gavrilovich. Now, many years later, Croatia argues that this process of acquiring these companies through the bankruptcy process were procedurally not compliant, and they also had allegations of fraud and corruption, right? So the query is, can you attribute the decisions of the bankruptcy proceeding, the bankruptcy counsel, to Croatia, or are these independent proceedings? And again, the way the process generally works is the tribunal looks at the domestic law framework. In this case, they say that the constitution of the council is through statute. They're exercising court functions under Croatian law. And the point essentially that the court, that the tribunal concludes is that since under Croatian law, you were exercising Croatian functions, the actions are attributable to the respondent, to Croatia. I just want to point out, this is not to suggest that it's always the case. It's a fact-driven inquiry. You look at domestic law and see whether under domestic law, the actions of the trustee, the actions of the administrator can be attributed. I've given you 2 examples here where under domestic law, the tribunal says, no, they are not attributable to the state. So the point, the takeaway, this is a fact-driven inquiry. The last point, can you challenge arbitrators for decisions they make in bankruptcy? This is a decision that came out this week, and unknowingly, the award was made public just yesterday. So I'm going to get in and out of this very quickly in the interest of time. I'm again focusing on very few issues. In this particular decision, the claimant challenged the entire tribunal, all 3. And their challenge has many dimensions. The point I'm going to focus on is that the tribunal allows the court-appointed administrator to represent them, right? So some of the shareholders say, no, we don't want the administrator to be representing us. We have somebody we have elected, and the tribunal has rejected that person. And their argument is, look, we're going to be questioning the bankruptcy proceeding, having the administrator, their point ergo being a state person representing us is not, this is a conflict. The matter goes, under ICSID's procedure, it goes to the administrative council. And the finding, just to summarize it on this point, is, look, there is a high threshold. The threshold is manifest lack of independence and impartiality. And they said, at this stage, your arguments are just speculative or hypothetical. And the tribunal did not ignore. The tribunal actually did expressly make a finding looking at the facts. This does not meet the high threshold. Now, again, there are so many issues to cover in bankruptcy and how it may impact investor state. We obviously can't delve into all of them, but this is a super high level introduction to some of the issues that come up. With that, I think I'm 1 minute over time, but I think I did good considering no one was monitoring me. I will stop.
You're always fantastic, Kabir, and that was quite a multi-cuisine that you took us through. And a lot of developments have also been taking place of late in investment arbitration, especially in the cases of Turkmenistan, where security for costs has become a concern, especially when the claimant is an insolvent entity and the respondent is seeking security for costs. So to shed more light on the entire concept, I now invite Elizabeth Snodgrass.
Thanks, Ishan. Let me just get the slides up and running. There we go. Pick the right version of the screen. Excellent, thank you so much. I'm going to cover the first few points that I was going to cover quite quickly in the hope of making up some time. But I thought it would make sense just to start by ensuring, if I can figure out how to drive these slides, that we're all clear what we're talking about here. So to echo Kabir, at the risk of insulting your intelligence, we'll spend a minute just making sure we all know what we're talking about. So an order for security for costs is a specific type of interim or provisional measure that is sought during the course of an arbitration by the party that is usually a respondent to the claim or a respondent to a counterclaim, seeking to ensure that if in the future it is the beneficiary of an award that the claimant should pay its legal costs and arbitration costs, that claimant will actually be able to do so. So an application for security for costs, an order for security for costs, is potentially a powerful tool to disincentivize frivolous claims and to reduce the risk of what has been called arbitral hit and run, where a claimant who is itself judgment proof brings a claim, in the typical scenario, a claim funded by a third-party funder that is arranged on the basis that the funder will not be responsible for an adverse costs award, causing the respondent to incur material cost in defending the claim in circumstances where there's no meaningful prospect of the respondent recovering costs, even if they are successful in defending it. So if an award for security for costs is granted and is not provided, the claimant can find its claim stayed or ultimately struck out, dismissed. So the stakes are high. And therefore, in considering any application for security for costs, tribunals have to resolve a fundamental conflict between, on the one hand, access to justice for the claimant, and on the other hand, protection for the respondent against being required to incur ultimately irrecoverable legal costs in defending a frivolous claim. Very quickly, let me figure out which button to press. A moment on the context in which the issue arises, and a very short point here, which we just shouldn't lose sight of. The possibility of an order for security for costs arises only, of course, in arbitrations where the arbitral tribunal is authorized to allocate costs, to make an order that the unsuccessful party should pay the successful party's cost. That is, of course, not universally the case. More typically not more typically, but sometimes in a commercial arbitration, you will find that the parties will expressly have foreclosed a cost allocation award or a cost shifting award. And obviously in that sort of context, there is no power for the tribunal to order costs, and therefore the question of security for costs doesn't arise. Turning now to very quickly the basis and the legal framework for the tribunal's authority to order security for costs. As you can see from the slide, this is often expressly stated in the arbitral rules or in the relevant arbitration statute that applies as the lex arbitri on the basis of the seat of the arbitration. Sometimes you can also see this expressed explicitly in the arbitration agreement itself. There you have an example from an investment treaty that itself makes clear that an application for security for costs is permitted. Even when arbitration rules, and many of them don't, expressly indicate the arbitral tribunal's power to order security for costs, there is widespread consensus, although I imagine there's residual controversy about this, that the tribunal's general authority to issue interim, provisional, or conservatory measures is wide enough to authorize this specific kind of interim or provisional measure. So that's the sort of legal framework, the rules of the road. Turning now, and I've made up good time, to the legal tests that are applied in determining applications for security for costs. And this is where it gets interesting. So it's hard to say that there's a uniform rule, given that all of the legal framework depends on numerous different sources. But looking at the case law, it's possible to discern essentially a three-step analysis that is usually conducted when tribunals decide on applications for security for costs. As a first step, tribunals conduct some prima facie analysis of the likelihood of the party pursuing security prevailing on its claims or defenses. So a cost award is only going to be made in favor of a successful party. So a threshold question for the tribunal is, does it look like there's a reasonable possibility that this party will succeed? It's important for tribunals at this interim stage of the arbitration not to prejudge the merits of the case, so they conduct only a prima facie analysis of the merits at this stage. The second step of the analysis is for tribunals to consider the claimant's ability to satisfy an adverse costs award and the availability of the claimant's assets to be enforced against. So they consider, for example, whether there is a risk that the party from whom security is sought is not going to be able to pay, or that their assets are shielded or sheltered in such a way that enforcing against them will be difficult. Fundamentally, of course, that's a factual inquiry. And as a factual inquiry, the party who is seeking security for costs in principle bears the burden of proving that there is a risk or an inability to pay. In practice, what this involves is identifying some facts that call the solvency or ability to pay into question, and then shifting the burden to the claimant to explain why those facts don't support the inference that it will be unable to pay. So what are some facts that have been relied upon to support applications for security for costs? One hot topic is the fact that the party against whom security is sought is receiving third-party funding for the claim. There is a vibrant debate over whether the simple fact of third-party funding should suffice to establish doubt as to the claimant's ability to pay an adverse costs award. Some arbitrators go so far as to argue that the simple presence, the very fact of third-party funding itself, should give rise to a presumption in favor of security for costs. In investment treaty cases, such a hard and fast rule has generally not been accepted, although the presence of third-party funding is definitely a factor that is taken into account in assessing applications for security for costs. And looking at the cases, you can see that where the terms of the third-party funding expressly exclude coverage or funding for an adverse costs award, tribunals are inclined to award security for costs. Whereas in a case in which the terms of the third-party funding required the funded party to maintain insurance that would cover an adverse costs award, the tribunal was satisfied there that there was sufficient what they described as at least some non-trivial cost coverage, and so they declined to order security for costs. So this emerges that the precise terms of the funding and how it approaches liability for adverse costs emerges as a potentially crucial dividing line about the extent to which third-party funding will be a factor in an application for security for costs. Other factors include, evidence that the claimant has taken steps to shelter its assets, that they've been transferred to a jurisdiction or alienated in a way that makes it difficult to attach them, particularly when this appears to be deliberately done to make oneself judgment proof. And of course, fundamentally, and what makes this quite relevant, unfortunately, in the current context, is insolvency or bankruptcy or other indicia of financial distress. If the factors that are said to give rise to this concern about the ability of the claimant to pay can be said to be factors that were understood and accepted as business risk at the inception of the parties' relationship, and in this way to have been foreseeable, then in principle, you have a good argument as the claimant against whom security is being sought that they should not support that order for security for costs. So for example, if it can be shown that a party knowingly contracted with a shell company, had no assets, was maybe part of a corporate family that did, but didn't take the step or the care to obtain a guarantee either from a corporate parent or otherwise, then you assume that counterparty risk when you enter into that contractual framework. And the fact that the shell company has no assets isn't a surprise to you, and therefore this is not some new fact that needs to be taken into account and your interests protected by an order for security for costs. The third step of the analysis, and this is where it gets interesting, is the balance of harms or balance of prejudice or broad fairness and equity considerations. So tribunals, having determined that there is sufficient indicia of some inability to pay, that's not the end of the story, and tribunals go on to consider a range of issues, including access to justice, so not wishing to allow an award of security for costs to impede a meritorious claim simply by making it too expensive for the claimant to proceed. Tribunals also broadly consider issues of equity and fairness. So critically, if the reason that the party's ability to pay is now being called into question is an action that the party seeking security itself took, then there's good support in the case law for the view that the party who created the situation that resulted in insolvency or financial distress can't invoke that situation as the basis for security for costs. So just to give a concrete example, if the source of income for a claimant was a mine, and the respondent expropriates the mine without paying compensation and therefore pushes that company into bankruptcy, there's a strong equitable argument that the respondent can't rely on the fact that it has bankrupted the company as a basis for obtaining security for costs. Other considerations in this equitable balance of harms, balance of prejudice context include whether the application is tactical, playing for time, or seeking to disadvantage the claimant, and also whether the party who's applying for security for costs is essentially in good standing with the tribunal in terms of having paid its own share of advances on costs and other expenses in the arbitration. In the investment treaty context in particular, there's sort of an overlay of what's been described as an exceptional circumstances requirement. So to succeed in obtaining security for costs in that context, tribunals have emphasized that this is a very high threshold. And to give you a flavor of how high this threshold might be, I've put a quote on the slide there from Limonenko versus Turkey, which emphasizes only in the most extreme cases and essential interest of either party, the danger of irreparable damage, that the possibility of granting security for costs should be entertained at all. So quite a forceful amplification of the standard. In conclusion, and I really am trying to keep under my 15 minutes, I think there are a couple of takeaways from this lightning fast survey of the law of security for costs for the purposes of the discussion about the post-pandemic context we're having today. So the first is that insolvency in and of itself, the insolvency of the claimant, is not enough to guarantee that an award of security for costs will be granted. And this is usefully illustrated actually by the Turkmenistan case that was mentioned earlier, an ongoing investment treaty case that has recently been in the news. So this is an ICSID arbitration that was initiated back in 2018 under the Germany and Turkmenistan BIT. The claimant company has been placed into administration, and its insolvency administrator, a Mr. Dirk Herzig, is the named claimant in the ICSID arbitration. The respondent state made a request for security for costs at an early stage of the proceedings, and that request was first ruled on in January of this year, and a majority of the tribunal granted the request. The basis for the grant of security for costs in that case was two factors. First, the insolvency of the claimant, and second, the fact that the claimant was in receipt of third-party funding, which was how it was able to bring its claim, and the terms of that third-party funding did not make the funder liable to pay an adverse costs award. So that dividing line I identified at the outset. And the tribunal ruled that those two facts together met the exceptional circumstances threshold and justified awarding security for costs. The claimant, which was the insolvency administrator, was required to post security in the amount of $3 million. And in the January order, the tribunal indicated that if the claimant faced insurmountable obstacles in obtaining that security, he should come back to the tribunal and the order would be revisited. Well, as it transpired, the insolvency administrator did face insurmountable obstacles in coming up with $3 million or arranging a bank guarantee in favor of an insolvent entity. And on that basis, he went back to the tribunal and requested the tribunal to reconsider the award of security for costs. And in an award dated 9th of June this year, a majority of the tribunal rescinded that order from 6 months ago, finding the administrator had shown that he was not able to obtain the ordered security on reasonable terms. It didn't overturn its original finding that there was a substantial risk, that Turkmenistan faces a substantial risk of having a costs award in its favor that it will not be able to collect on. But the tribunal found that to deny the administrator an opportunity for the claim to proceed to the merits, and here, importantly, in circumstances where the respondent's actions are said to be the cause of the insolvency in the first place, would be to deny access to justice, and that in the circumstance, the balance of harms didn't support an award of security for costs. So this case is a powerful illustration of the fact that the simple fact of insolvency of a claimant will not be the end of the analysis in considering an application for security for costs. Factors such as the reasons for the insolvency, the practical availability of security, and overriding concerns about access to justice will also have to be weighed in the balance. A second takeaway in considering security for costs applications in disputes arising in the post-pandemic context is I think we'll expect to see a lot of attention paid to this argument that the reason the claimant is facing financial difficulty is because of things the respondent has done. This is sort of an obvious paradigm or an obvious potential issue in an investor state or any kind of claim against a state, where the argument might be that the very measures that were imposed to address the pandemic were the thing that caused financial distress. And I would have thought certainly worth exploring the argument that in that circumstances, security oughtn't to be ordered. To be clear, this is a much less clear-cut weighing of the equities than you might have in an uncompensated expropriation, because it may well be that there were entirely legitimate justifications for the measures that were taken, but I can see this argument being run. I can also see a similar argument being raised in a purely commercial dispute. So say a supplier ceases to supply material to a manufacturer claiming force majeure or frustration or whatever. The manufacturer loses its ability to generate any income and ends up insolvent. And in a claim by the manufacturer against the supplier, I think it would be open for the manufacturer to say, well, you know, look, you can't, the manufacturer can say, look, you are the reason, supplier, that I am insolvent, and you can't therefore rely on my insolvency as a basis for an application for security for costs. There, I think we enter into interesting territory where, in order to weigh that up, the tribunal might well have to go a little further to evaluating the excuse that's being put forward by the supplier. And given that it is acting at only an interim stage of the proceedings, is under an injunction not to prejudge the merits of the case, I think they would have to be very cautious in sort of doing that weighing of the equities in that context. I'll stop there in the interest of time and not completely overtaking the remaining session. Thanks very much.
Thank you so much, Elizabeth. That was indeed quite insightful. And before we move further, I just need to announce that we are likely to cross over 1 p.m. here Eastern Time. So for anyone who has any questions, we can likely extend the webinar by another 10 minutes. And it's very important to understand the perspective of third-party funders. So I now invite Dana McGrath to please talk about what third-party funding is and how it works.
Good morning, good afternoon, good evening to all of you. And thank you very much, Chris and Ishman, for inviting me to participate in this program. And I'm conscious that I am the last of many speakers and there's time for questions allotted at the end. So I am going to try to narrow my remarks to some key aspects and try to connect to some of the things that have been said by our colleagues earlier in this program. First, I think it's undeniable that the economic downturn has prompted clients and law firms to consider third-party funding for litigation and arbitration more than ever before, not necessarily because their clients or the firm are threatened by insolvency or impecunious, but because this is a topic that everyone is looking at. The economic downturn could go on for some time, and people look to third-party funding as a cash management tool, as well as a resource if, in fact, a party is impecunious. So in that respect, I think that many people are asking and learning about third-party funding who might not have been so interested in the topic before. And I will do as some of my colleagues had, take an opportunity for one brief moment of 101 intro to third-party funding in case any of you are truly not familiar with it. So some really basics quickly. It's non-recourse funding. So the third-party funder provides capital to a party in this case, an arbitration. And if the arbitration is unsuccessful, they do not get their money back. It is not a loan, it's non-recourse. They do not get any money. So third-party funders obviously have an interest in understanding the strengths and weaknesses of any case in which they invest, whether it be in the context of single case funding or portfolio funding. So a question that has been asked often is, what are the investment considerations by funders? What are the considerations that someone like me and other investment managers at funders look at to decide whether a case looks like a case that should be invested in or funded? So the first focus in that respect is the strength on the merits. Now, often we look at cases at a pre-filing stage. So I don't mean to say that our view of the case is the view that should be adopted by a tribunal. We look at it through the lens of the evidence, factual and legal, and potentially a summary of testimonial evidence that is provided to us or previewed to us through counsel and the materials provided to us to assess whether we can find the case, a strong case on the merits. So one of the myths, I think, that keeps being repeated, and I'm not quite sure why, is that third-party funders are funding meritorious, or funding claims that are frivolous. I don't think that any third-party funder would affirmatively choose to fund a case that was frivolous. I think the third-party funders look at cases and they weigh the merits very seriously. So those of you who are looking for third-party funding, whether it's for cash management for your clients or your law firm, or whether it's because of the economic downturn, it's really important to convey to third-party funders the strengths and the weaknesses of the case as objectively as you can, to allow the funder to truly understand the nature of the case. Another thing that we very much take into consideration, and I do believe that the pandemic and the economic downturn intersect here a bit, is the length of the case. So there's been some proceedings that have been put on pause due to the pandemic and court closures or court suspensions. Less so apparently in the international arbitration space, which I think is a fantastic testament to international arbitration truly being a fantastic dispute resolution system for international parties. That said, if a case goes on for a very long time, that's a factor that a funder will take into consideration in choosing to fund it. And also, quite frankly, the cost of the capital provided to the claimant. So the likely time to the collection of the award or a settlement is definitely a factor that is considered. And finally, and this also connects to the insolvency discussions that we've been having, funders look at the recoverability or collectability of an award or a judgment as against the respondent. So a lot of what has been said today has focused on a respondent collecting an adverse cost award against a claimant. Funders are very focused on the ability of a claimant to actually be able to collect against a respondent, be it a private commercial respondent or a sovereign state. So we look at that at the beginning when we're evaluating a case, and obviously it's something that we take into consideration, watch throughout the case. Our company and other companies may, but certainly our company has a department that actually is focused on analyzing the ability to enforce against an entity that we might fund a claim against. And so that enables us to be able to make that assessment an internal assessment on our side. So in terms of approaching a funder, which seems to be increasingly the trend these days, given the economic situation, it's true that funders typically reject more cases than they accept because they do look closely at the strengths and weaknesses of the case, and they look for cases that will be meritorious. So it is very helpful for claimants and for law firms representing claimants in presenting a case to a funder to have spent the time and done the preliminary analysis necessary to be able to present the case clearly, either in written form or in a PowerPoint type presentation delivered by counsel, all of which is covered by a non-disclosure agreement. If you present the case to a funder in a clear and organized manner that reflects meaningful preliminary analysis of the claims and its weaknesses, and have done a fair assessment of the damages, it makes it much easier for a funder to understand the case and evaluate it with respect to whether it is an appropriate investment for the company. I would also encourage you to know your audience when you go to funders. Many funders have former practitioners like myself who have been in your shoes and practiced for 10 or more years, in my case 20. So we do know what to look for in a case, and we look for a collaborative relationship with the law firm and the client in understanding the case, and if we fund it in understanding how the case unfolds. So I think it's important. Another myth is that the funder is just sort of a source of capital. We are a collaborative partner with you. We do not run the case. The client and the counsel run the case. But we like to have a positive collaborative working relationship with our clients and with the law firms who are representing claimants in these matters. To touch on the issue of security for costs, in some cases, clients get their own insurance, ATE insurance. In some cases, they look to us to facilitate obtaining that insurance. And in some cases, clients make the choice not to take that insurance. So I think that the application or the consideration of whether a client has such insurance, needs to be looked at, not through the lens of there's a third-party funder and is there insurance. It's really the claimant and the client that considers these issues with its counsel and with a funder. So sometimes a funder is approached and counsel says, oh, the client's already doing it, it's getting its insurance. That's not even an issue for funding. So I just want to, I don't say that the issues are entirely disconnected, but they are not totally connected either. It is really, it depends, it's a case-by-case issue as to whether the client gets that insurance. And we do have the ability, at least at my company, to facilitate getting that kind of insurance if that is needed. I think it was interesting that the test, no matter how articulated with respect to security for costs, is on the one hand expressed as it's supposed to be prima facie and not considering the merits of the case, but yet at the same time, the issue arises as to the responsibility, potential responsibility of the respondent for the unfortunate financial circumstances the claimant may find itself in this arbitration or dispute. And so I think it's very difficult to apply that test with no consideration of the merits, even though I think that that is strongly the desire. of the tribunal to not prejudge the case. And I understand that, you know, that the issues are really like pressed to the tribunal to consider as much of the circumstances presented in support of an application for security for costs while trying not to prejudge the case. It's a very difficult situation the tribunal is put in, especially if the clients become impecunious potentially in connection with the substantive issues that are to be decided in the arbitration. So I think that we're going to hear more on security for costs, applications for them. You know, it's indisputable that the vast majority of applications for security for costs are denied, but it's a complicated issue, and I think it will be increasingly complicated given the economic downturn, the increase in third-party funding increasingly of parties that would otherwise be unable to bring their case to arbitration or to litigation because of the economic situation they are in. So on that note, to allow some time for questions, I will close and turn it over to Sham and to the audience for questions.
So thank you so much, Dana. In fact, I can see that some questions have already been answered individually, but there's one question, Dana, I'll ask because you're already speaking that. There's a question from Mitesh Moda. He asks, if the terms of a funding agreement are key to determining the likelihood of security for costs being ordered, how does the tribunal address issues of confidentiality in respect of the funding documentation? So the primary question appears to be that are documents only disclosed to the tribunal and not the respondents? The funding arrangement overall? Dana, you'll have to unmute yourself, please. Dana.
So I was squinting to try to read the question, but I realized that I think you've captured it well. You know, I think that the issue of whether the funding agreement provides for security for costs, if asked by the tribunal, if that issue comes up in a case that's funded, I do know that tribunals have, in some circumstances, reviewed in camera the funding agreement. I know in some circumstances, a claimant may volunteer the fact that the funding agreement does in fact provide for ATE coverage, and that it's not necessary to review the funding agreement because representations are made by the claimant with respect to that the relevant term, specifically whether there is ATE insurance or, you know, the funding agreement covers security for costs. So often that issue is obviated by the claimant being very forthcoming about whether it is included or not included.
Thank you. And there's another question by Luis Enrique Coervo, who asks that a stay order, I believe in the sense of bankruptcy proceedings, a stay order stops any litigation against the debtor, including arbitration claims. How could an arbitration award be disregarded, or an award that disregards a bankruptcy stay order be enforceable under basic public order principles? So if I were to rephrase this question, it would be, how can an arbitration award or an agreement be enforced against the public policy? So if any of our panelists would like to take this question.
I do so with pretty great trepidation because I'm not an expert on cross-border insolvency, but my sense is that what might happen is that you have an award, you have bankruptcy happening in one jurisdiction, you have an award rendered somewhere else, and you have enforcement sought in yet a third place. And so the argument that you've implicated the public policy of the forum in which enforcement is sought is not direct, right? You're saying, oh, you forum should respect the public policy, the imprimatur, the primacy of a bankruptcy court or administrator somewhere else. And those who know more about the cross-border insolvency context will be able to tell us whether there are actually mechanisms for directing traffic in that way. But I think that's where the gap comes in, is you're not necessarily in the same jurisdiction in which the bankruptcy is being administered.
I'm going to agree with what Liz just said. I mean, the cross-border insolvency context, the part of why it's so prickly and complicated is because there's no requirement on the tribunal or any other jurisdiction to really recognize or give any legal effect to that proceeding or what that legal proceeding may mean. In particular, because in the insolvency context, it's possible that it has a different meaning. It comes back to capacity. What does it actually mean in the local law, and how does that differ, and how do you interpret it? It's a complex question that I think there has no easy answers.
Yeah, I believe the problem with this interplay is that there are no easy answers. And another question on this interplay is by Medot Tesfaye, who asks, can we say that the trustee and or the administrator appointed by the courts takes over the rights and duties of the estate and therefore represents before the arbitration tribunal, and only the court has the right to rule as to the capacity of the trustee? So the question, in fact, I would also add to it, whether the tribunal or a court can actually decide the capacity of the trustee to present the claim. So this becomes a question of locus. Kiran, are you answering that?
Go ahead. Okay, I'll give it a shot. Well, the question of capacity is an interesting one, because I'm not sure if the trustee necessarily lacks capacity or doesn't have, or has or doesn't have capacity. It's whether the party has or doesn't have capacity. So the question becomes, who is representing the party in the arbitration, number one. Is it happening vis-a-vis the trustee and counsel designated by the trustee for that purpose, or is the party actually still continuing to maintain some capacity and be able to do that? So for example, in the US under Chapter 11, the party would retain its capacity. So that's one angle and one aspect of this. But the other aspect of this becomes whether, in this cross-border context, whether it's all being interpreted in the same way with respect to legal effect. I think, I hate not answering questions when a question is sought, but I think unfortunately that's where I end. But I'm actually very curious to hear what Professor Rooney might think, if he has anything to add, because I think it is also, there's an element of it that's also contractual and substantive.
I think everyone can hear me now. Yeah, I think the question is, in fact, a very interesting and complex one, as Karen had mentioned. And there is an interplay, I think, between the cross-border insolvency regulation as well. In part because one thing is that the cross-border insolvency regulation provides a procedure for the recognition of the foreign bankruptcy representative. So to what extent that might be relevant is, I think, also a consideration to take into mind. I did have a situation one time as an advocate, basically, where in the course of enforcing an award, we put the respondent into liquidation in its home jurisdiction. And then there was a collateral action going on in the place where the award was issued. And the other party never did, nor did the foreign bankruptcy representative, ever think to utilize what for the US is Chapter 15 of the Bankruptcy Code, which is the UNFITROL cross-border insolvency division, right? To qualify the foreign representative, which I never really quite understood. But it is a complicated question, I think. And like many of them, as I think Karen had mentioned, one likes to answer the question, but many of the basic points and issues in what we do is oftentimes not really susceptible to a definitive quick answer.
Thank you, Professor Rooney. And there's another question. I think this would be the last question we take up. It says, it's by Alexander Bedros, which says, under most domestic insolvency laws, all claims against the debtor must be stayed or centralized before the insolvency court. Therefore, if the claimant in an international arbitration is in insolvency, must a tribunal refer any counterclaims by the respondent to the domestic insolvency court? What if the claimant entered insolvency during the arbitration proceedings and the respondent's counterclaims were already pending? I think this is a question which touches upon both the theoretical and practical aspects. If anyone would like to answer this one.
I'll give that one a shot because I have a case right now where that's precisely what's going on. The question is, who does the counterclaim belong to? Does it belong to the trustee? So in the case that I'm dealing with, it's a Chapter 11 bankruptcy, and the arbitration just happens to be seated in the US as well. So although it's an international arbitration, the seat and the national insolvency law are shared. And that's another element. I didn't talk about this in my presentation, but in the entire cross-border insolvency context that I presented, it assumed that there's a foreign seat, that the insolvency proceedings are happening in a different jurisdiction than where the arbitration is seated. But where it gets differently complex is where the seat and the place of insolvency proceedings are shared and in the same national jurisdiction. So what I would suggest there is, I think that question becomes simpler in the domestic context. So I think that it's easier for a tribunal to take judicial notice of the insolvency proceeding, should that be the case, where the seat and the procedural law are shared with whatever the insolvency law may be. And I also think it simplifies the question of counterclaims, because I think it gives the trustee administrator the jurisdiction over those counterclaims, the ownership over those counterclaims. If you have a different seat and a different law for the insolvency jurisdiction, the question, I think it's a question of domestic law for the insolvency proceedings. What does the trustee actually have the right over? Is it simply to reorganize assets, administer assets, pay debtors, pay creditors? It depends on what the scope of that right is. And the scope is different in different national contexts, and it's also different when you compare civil law and common law tradition jurisdictions as well. So it becomes a patchwork in that sense, but I think you look to what the domestic insolvency law says to what the role of the trustee is.
True, correct. In fact, another role of the trustee is to maximize the value of the assets, and which may entail participating in proceedings, or which may also say, no, you should stay away, otherwise it's going to come with a lot of costs.
Or it may entail maximizing the payments to domestic creditors, right? So the question becomes which creditor has the primacy over the claims, and whether the foreign or the domestic creditors get greater jurisdiction and get greater weight in that particular national context.
Yeah. So I think if any of the panelists has anything to say regarding this interplay between arbitration and insolvency, please feel free. Or maybe we can just.
I would just note that that we very much appreciate that some of the companies that are considering or going into insolvency, do have claims that need to be pursued. And so funding actually goes in that direction too, to support insolvent companies being able to assert their claims to preserve the estate and protect as much as possible.
Fantastic. So I think we've covered a lot of ground and how this near future is going to be, especially given solvencies across the world getting affected. There's going to be cash crunch, liquidity is affected, and third-party funders, of course, making stronger statements across the world as to the importance they have and and thank you so much to all the panelists for sharing their insights, their experiences, and for answering all the questions. It was indeed a fantastic discussion, a lot to be learned, and a lot has been learned, gratefully. So thank you so much, everyone.
Thank you as well.
Thank you, Ishan.
Thank you.
Thank you.
John, Kieran, Kabir, Dana, Liz, all of the people listening in and asking such great questions.
Thank you,
and
Chris.
before you sign off, may I just suggest to all the attendees that next week at same time we will also be having a primer on cross-border insolvency. It will be conducted by a former chairman of the UNCITRAL, Dr. Francisco Reyes Villamizar. So we will send out the links for that as well. And please feel free to log in, to join, to understand how cross-border insolvency works and how you can learn about it. So thank you so much again to everyone.
Thank you. Bye-bye.
Thank you so much to all the
Thank you.
panelists. Thank you. Thank you.